Hello, Namaste, Adab, Sat Shri Akal. I, Sakshi Kilawat, back. And this time we are going to discuss current affairs issues from the month of May of 2022. In this section, we are going to discuss polity and governance issues. And the very first topic is reform in seventh schedule. It was in news because many experts advocated revisiting the seventh schedule of the Indian Constitution. Let's see about the seventh schedule. Seventh schedule, which comes under Article 246, and it provides distribution of powers and responsibilities between the state and central government. It is basically called as the separation of powers. It specifies the roles and responsibilities into three lists, namely union list, state list, and the concurrent list. Union list, which deals with the subject on which the parliament may make laws. The subjects which covers under the union list, parliament can make laws on those subjects, while the state list details those which comes under the purview of state legislatures, and the concurrent list had subject in which both parliament and state legislatures have jurisdiction. Both can make laws on these subjects under the concurrent list. However, the constitution provides federal supremacy to parliament on concurrent list items in case of conflicts. This means when in case parliament and state legislatures simultaneously or makes the law on a similar same subject, there the law of parliament will prevail over the state legislature's law. Article 248, it confers residuary powers on the parliament. Residuary powers refers to the power of jurisdiction upon subjects that are not mentioned in the state or concurrent list. As per the Sarkaria Commission, concurrent list subjects which are neither exclusively of national concern nor of local concern, and hence occupy a constitutional gray area. Gray area as in which is not clearly mentioned or which is not defined anywhere. Obviously, when any subject is comes under residuary list, which comes as a residuary power, it mostly not be of the national concern or local concern, because if it would have been of the national concern or local concern, it would also automatically be in the under the concurrent list, under the union list or under the state list. Let's see the evolution of seventh schedule. Where does this starts or originate? In 1861 Act, that is Indian Councils Act of 1861, it brought provincial legislative councils, and it had substantial Indian representatives. In 1882, Lord Ripon's resolution, which introduced elected municipal councils and rural district boards. In 1909, that is Government of India Act 1909, it empowered provincial councils by enabling more Indian representation. And in 1919, the Government of India Act 1919 came, which relaxed central control over provinces by demarcating and separating central and provincial subjects. In 1935, the government of 1935 Act, Government of India 1935 Act, which laid down the scheme of distribution of legislative powers into three lists, which has been retained in Indian Constitution. This act also called as mini constitution. Seventh schedule contains three lists, that is list 1 or the union list, over which parliament has exclusive competence. For example, defense, foreign affairs, railways, banking, etc. subjects come under this list. Originally, there were 97 items in this list, but now it is numbered to 100. List 2 or the state list, over which the state legislatures have exclusive competence. Subjects are like public order, police, public health and sanitation, betting and gambling, etc. This list originally contained 66 items and now it is numbered to 61. List 3, that is the concurrent list, over which both parliament and state legislature have competence. List contains subjects like education, population control and family planning, criminal law, protection of wildlife and animals, forest, etc. This list um, this list contains 52 numbered items. It originally had 47. Let's see the rationale behind keeping seventh schedule in the constitution. To ensure unity and integrity of India, as when partition had happened in 1947, there was need for the integration of nation. It has an emphasis on national integration, and only a strong central government could manage the complex administrative problems. It also could protect the nation against external threats and invasions and maintain international relations. For enabling responsive governance, local governments under the state list are seen as encouraging political participation, accommodation of various views, and bolster rights of minorities and communitarian values. It engages the public policy making, its implementation, monitoring, and evaluation. Also, for achieving balanced economic development. Seventh schedule, it favors the allocation of legislative powers to the union government to ensure economic development at national level in a coordinated manner, which will bring parity in socio-economic development across states. For promoting diversity, allocation of legislative powers to state can promote cultural autonomy given the unique diversity in India with respect to its geographical area, population and number of languages spoken. Other reasons are, as per Joint Committee report of 1934, it was necessary to ensure that provinces remained truly autonomous, to determine their jurisdiction independently in order to bolster spirit of cooperation between union and state. Let's see the procedure for amending seventh schedule. It can be amended as provided under Article 368, which comes under Part 20 of the Constitution. It requires special majority of the parliament. Special majority is the majority of total membership of the house plus the majority of not less than 2/3 of the members of house present and voting. Also, the consent of half of the state legislatures by simple majority. What is needed is the special majority of the parliament and the state ratification. Other provisions that can be amended in such manner are election of president and its manner, extent of executive power of the union and the states, Supreme Court and High Courts. By the way, the ratification of state is needed as where and when the amendment of the constitution affects the state. The state ratification or the consent of half of the state legislature is required by the simple majority. As in the election of president, along with MPs, member of parliaments, MLAs also participate. That's why the state ratification is needed. The need to revisit seventh schedule. Why there is need to revisit the seventh schedule? As it is archaic. The present seventh schedule containing union, state and concurrent list, those were inherited from the Government of India Act 1935, and it needs to be updated with the changing time. For the service delivery, as citizens increasingly demands efficient delivery of public goods, but without delegation of funds, functions, and functionaries, which presently dominated by the central government, their local governments are unable to respond such demands of the citizens. Centralization. Items have moved from the state list to the concurrent list and from the concurrent list to the union list. It highlights that centralization in an area of decentralization, in an era of, sorry. For example, shifting of the subjects like forest and education from the state to the concurrent list by the 42nd Amendment. What will happen after the shifting of subjects? The Parliament also can make laws on this subject. Dominant position of center. In concurrent list, central law prevails in case of conflict between state and central law, effectively giving center dominance in concurrent list as well. Appropriate placement, ensuring that existing entries or new entries that are sought to be added are appropriately placed under the free list, highlighting the needs of governance in 21st century. Center-state conflict. Federal tensions in post-independence India, such as state demand for greater autonomy, further highlight the need for reforming the seventh schedule. Let's see some more details or related information. The doctrine of pith and substance. Here, pith means a true nature or essence of something, and substance means the most important or essential part of something. It says that where the question arises of determining whether a particular law relates to a particular subject which is mentioned in one list or another. The court looks to the substance of the matter. That is, the court looks to the essential part of the matter. Thus, if the substance falls within the union list, then the incidental encroachment by the law on state list does not make it invalid. Means if a union or the parliament has made law on the subject which comes under state list, but while categorizing or determining whether it comes under union list or state list, the court will look upon the substance of the matter, and if that substance falls within the union list, it may not invalidate the law. Supreme Court in various cases like Calcutta Gas Company case 1962, India Cement Limited versus State of Tamil Nadu 1990, Jilubhai Nanbhai Kachar case 1994, it referred to the principle of faith and substance. It is essential to ascertain the true nature and character of a legislation for the purpose of determining the list under which it falls. The doctrine of colorable legislation. It is based on the maxim that what cannot be done directly cannot also be done indirectly. It depicts the notion that legislation cannot be used under color or guise of power, which was conferred for one purpose and use it for some other, which is otherwise not valid. It is built upon the founding stones of doctrine of separation of power. It is tool devised by and applied by the Supreme Court to interpret constitutional provisions and to avoid any unjust or fraudulent use of Indian law. In Balaji versus State of Mysore case, Supreme Court held that the order reserving 68% of the seats for students belonging to backward classes was violative of Article 14 in disguise of making a provision under Article 15 Clause 4. It is the example which says that something which was conferred for one purpose and use it for some other purpose which is not valid. And let's see what Article 15 Clause 4 says. Article 15 Clause 4, it says that nothing in this article or in clause 2 of article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and the scheduled tribes. Basically, it empowers states for making any special provision for the advancement of SEBC by reserving 68% under this case for students belonging to backward classes. It violates Article 14 and is making use or like misusing this article clause of Article 15 clause 4. Now let's move to the way forward of this topic. A high-powered commission should be constituted, which may consist of eminent lawyers and jurists with administrative experience to examine the entries of list 1 and list 3, that is union list and concurrent list in the 7th schedule, which will suggest redistribution of the entries. There should be an institutional framework which will consider for a consultative forum for credible policy dialogue between center and the states to give a boost to cooperative federalism. The Sarkaria Committee recommendations from 1998 report, it focuses on residuary power and it says residuary powers should be transferred from the union list to the concurrent list. Exception is there as for residuary power which imposes taxes should be retained in the union list. It says on the concurrent list that states should be consulted by the center before exercising powers over the concurrent list. There should be the periodic review which will undertake periodic review of the list focusing on removal of outdated entries, addition of new entries, and appropriate placement of existing entries. As per Punchi Commission of 2010, Center should only transfer those subjects to concurrent list which are necessary for ensuring uniformity in basic issues of national policy. So that's all for now. And if you want to know more about the seventh schedule, go to this QR code, scan this QR code. You'll get the PDF document of 10 pages of weekly focus document, which is titled as Seventh Schedule of the Indian Constitution. Does it need a relook? We'll meet in another topic, that is death penalty, capital punishment. So signing off for now. Bye guys. Have a good day. Take care. Stay healthy. Stay safe. Bye bye.